The Supreme Court yesterday declared Senate President Ahmad Lawan as the authentic candidate of the ruling All Progressives Congress, APC, for Yobe North Senatorial District for the 25th February general election. In the lead judgment on the case, upheld by 3 justices against 2, Justice Sentus Nweze had faulted the approach of the claimant, Bashir Machina, in commencing the suit at the Federal High Court, Damaturu Division, by way of originating summons and without oral evidence to prove allegations of fraud. But a minority judgment by 2 other justices upheld Machina's earlier victory. President of the Senate, Ahmad Lawan, has described the verdict of the Supreme Court that affirmed him as a rightful senatorial candidate of the All Progressives Congress for Yobe North as democracy at work.
I didn't, as a person, as an individual, go to the Supreme Court to seek for a redress. But my party did, and my people, the people of Yobe North and Yobe State generally, and many political associates and well-wishers and supporters across the country and beyond, who showed interest that there has to be an appeal at the Supreme Court on this matter. So today, this victory is for all of us involved. I am the symbol, but the victory is for our party, the APC, and for democracy.
Joining us now is Abiodun Owonikoko, a senior advocate of Nigeria. Good morning, AJ Owonikoko, SAN. Thank you very much for joining us. Quickly, your take.
Good morning, Dr. Abati.
Good morning.
So, always a pleasure to start the day with you on Arise TV.
Thank you. Well, quickly, your take on this ruling by the Supreme Court that has been, criticized here and there, and, what do you think it means for the democratic process? Do you agree with the view that has been expressed by some people that, the majority decision was arrived at per incuriam, and that the minority decision, will seem to accord more with the emotions of Nigerians?
Thank you very much. A word of caution to start with, which Dr. you yourself earlier alluded to. For a professional lawyer, commentary on judgment of court should be derived from informed position. And that informed position can only arise from having cited and perused the judgment of court. Be that as it may, questions about right to contest elective office in the public space, involves more than the interest of lawyers. Ultimately, it's about the people's mandate. So when the court hands down a judgment that can impact the outcome of the general election, we cannot shy away from having to interrogate the judgment. More so because it has implication for perhaps a lot more other cases that are still traveling their way up to the Supreme Court, based on the same or similar grievances. That said, what I take from the judgment of the Supreme Court is that it's a demonstration of the robustness of intellect of their lordships, that after listening to all the parties, the court was open to be persuaded, and the advocate successfully won majority of the hearts of their lordships. And some of the arguments also prevailed for those who did not succeed. A 3-2 judgment of the Supreme Court is a judgment that always has to be interpreted with carefulness and a sense of history. Because what is a minority judgment today may tomorrow become the majority judgment. That being the case, my understanding of what has happened in Supreme Court is that the court did not determine the merit of the case. So this point has to be clearly explained. When the court says that the mode of commencement of an action was improper, and that being a threshold issue prevents it from going into the merit of that matter, then the merit of the case has not been pronounced upon. But the effect of that pronouncement by the highest court in the land is, technically speaking, is also the determination of the merit, because that is the final bus stop. You have nowhere else to go except to God to reveal their judgment. So what has happened is that the majority of the court decided that the mode of commencement of the action did not validly activate the jurisdiction of the trial court, and that therefore it was not open to the trial court, the Court of Appeal, to have gone into the merit of a case that was not properly instituted. That would have been a strange attitude for the Supreme Court to take in a normal civil action. Because where a matter was wrongly commenced by the mode of commencement, either using originating summons or petition for writ of summons, the attitude of the Supreme Court has been that the form should not defeat the substance. And in such a case, oftentimes they will remit the case back for rehearing properly at the trial court and other pleadings. But this is not the case in election matters for two reasons. First is that election petition proceedings are in a special class of their own, regulated by special procedures, which are strictly adhered to, and therefore there is not too much of room for the court to accommodate liberalism. The second is that election matters are time-bound, and so once you have exercised the 6 months, 180 days that the trial court has, and 60 days that the Court of Appeal has, by the time the matter gets to Supreme Court, it's almost impossible for the Supreme Court to make any remedial orders which will involve having to rehear the case. So that explains why a lot of people who do not understand the workings of the court system may want to fault or criticize the judgment of the court. And they will begin to cite authorities that apply in normal civil cases. Whether the majority came to the right decision or not, or the minority, which having not agreed with majority, decided to delve into the merit of the case, would prevail in a future case is in the womb of time. But I'm happy that the minority decision actually represents the correct position of the law if the merit of the case is to be interrogated, because they decided to look at the case on the merit and concluded that having regard to the facts, there was no basis for the APC to have forwarded the name of Senator Ahmed Lawan, Marchina having emerged in the previous primary, and INEC having not supervised the second primary that was held, at which Senator Lawan emerged. So in terms of merit of the case, if people want to be fair, they should look at the reasoning in the minority judgment that actually decided the merit. In terms of the fate of the case, then we are bound by the pronouncement of the lead judgment of Justice Nweze.
Well, thank you very much, Mr. Owonikoko, for explaining that. But I'd like us to delve in, if you don't mind, into the judgment of the dissenting judgment. One of which, as you mentioned, was cited was the fact that, and as was mentioned earlier on during the analysis, was that the primaries, according to the Electoral Act of 2022, which is being tested for the first time, chiefly in these elections, is that you cannot contest, a candidate cannot contest in two primaries. In this case, Senator Ahmed Lawan had put himself up for the presidential primaries of the APC, and then, according to the APC, on the 9th of June, a runoff election for the senatorial primaries in Damaturu in Yobe North. What's your, going forward, for a future judgment, how does that play out? How is that interpreted for candidates in future elections?
Now, my understanding is that you cannot contest in two primaries at the same election. But you can contest in a primary if you lose and there is a rerun for another office. You can then put yourself up. What happened in this case was that Senator Lawan emerged from a second primary, which ordinarily should hold if the first one was, for any reason, truncated. So there is whether that could have been validly done in this time space we have, in this case, is a different thing. Because for the new primary, there should be 14 days notice to INEC. I'm not too sure that the time interval between when Ahmed Lawan lost the presidential primary. And when this fresh primary of APC for Yobe North was held, will have sufficiently provided a basis to say that there was a valid primary. And I think that's one of the things that their lordships who wrote the lead judgment, the minority judgment, took into account to say, look, a primary held without INEC supervision is not a valid primary. But that's going to the merit of the case. Unfortunately, that merit of the case is not open to be explored when the foundation of the suit already defeats its competence. So it is not correct to say that you cannot contest in two primaries. You cannot contest in two primaries at the same time. You can't be a candidate for presidential election, an aspirant, and an aspirant for senatorial election at the same time. How Senator Lawan eventually emerged as APC senatorial candidate for Yobe North, it's a different thing entirely. I'm not too sure that we can find answer to that in that judgment.
Okay, good to see you again, Amiable SA and AJ Owonikoko. Happy New Year to you, and it's a pleasure talking to you.
Same to you, sir.
Yeah, just to even expound on what you said, the primaries of the APC was the 28th of May. This second primaries, this runoff, was on the 9th of June, and you talked about the 14-day window. So that's like 8 to the 9th. That's like about 11 days. So it doesn't even meet the threshold of the window. That's number one. Number two, I also want you to even extend it beyond this judgment, because we've seen two occurrences, and that's why people are up in arms. I get all the technicality about the Supreme Court so that somebody, doesn't commit contempt of court and everything, but this is just for robust public engagement. These same circumstances who played also in the Akpabio case. And also, the political party stood strong on all of this, and in the end favored Akpabio, just like it is, in favor of Ahmed Lawan now. And a lot of people, are up in arms. And the dissenting judgment also even said, awarded a 3 million naira penalty to the APC for bringing such an incompetent case. So if the dissenting judgment was even that hard line, then is it because the fact that once you have a numerical supremacy, that's the whole of it, in the Supreme Court? I mean, I just want to be clear on that. I'm as lay as anything. I would not say I'm a lawyer or anything, but also I understand societal trappings and how things goes out. And I know the Supreme Court is not Father Christmas. What you put before it acts on. Hello, sir.
I think I lost you a bit now.
Okay, so I'm just saying, please juxtapose these two cases and the fact that it was not even up to the 14-day threshold before the next primary was held, and also the fact that the dissenting judgment even gave a penalty of 3 million against the APC for incompetence in this case.
Yeah, all right. Let me just say, the two cases are not were not decided on the same principles. Akpabio's case was decided on the merit in terms of the jurisdiction of the trial court to look into how parties field their candidates. Lawan's case was decided based on, if the Supreme Court view is to be taken, on what you can call maybe error of counsel in the way they approach the court. Because after a Davies case, if you recall, the same position taken by the Supreme Court in Lawan's was what they took in a Davies case, because that one was actually a case involving fraud. The allegation was that the PDP candidate presented false certificates and all sort of things. So there was practically no way you could have established that kind of allegation without pleadings being settled and witnesses being examined orally in court. In the case of Lawan, I do not recall what could have led to allegation of fraud with regards to purely legal complaint that this particular primary at which Lawan emerged was not a valid primary in the face of the law. However, you need to see the pleadings, you need to see the reliefs as couched at the trial court to see how the Supreme Court eventually came to make this a pivotal and decisive point to dispose of the appeal. So that explains the distinction between the two. Ordinarily, even if the case had gone to trial, if the position of the Supreme Court was that what you are litigating is an internal affair of the party, then the court would not have been entitled to look into the matter, which I think is the ground on which Akpabio's case was disposed of. That said, we also have to let the public be aware of some of the technicalities of advocacy. It is normally said that when your case is strong, you stand on the merit of it. When your case is weak, you go after the law. When both of these do not help your case, you go for technicalities. Now, in election petition cases, there's no better platform at which this play out better than election, where technical rules are given teeth, because the court is in a hurry and is overburdened, so that every case that is slightly improperly consulted will be thrown out. So we must appreciate that a good lawyer faced with a matter of this nature, when you see that the merit of this case may not advance your client's cause, you look at whether the law which the court will have to apply without a motion will help you. If the law will not help you, then you look at whether there are technical infractions and defects in the case, which once the court is faced with, cannot but uphold. These are things that probably will not advance a normal civil action or a criminal case. But in election petition, as a matter of jurisprudence, it is allowed. Because people must understand, in election matter, law, equity does not play a role. Election matter are based on the law. Whereas in normal courts, equity that will have come to ameliorate the strictures and strictness of the law is normally called in aid in certain cases to save an otherwise doomed matter for the purpose of the merit of the case. Okay. So this is my take on what we have doing.
I see a contradiction. I see a contradiction in some of your submissions, but yes, this is not the forum to argue that.
Okay.
First, the language of the Electoral Act says primaries, within 14 days. But the dissenting justices, they said, INEC must be notified within 21 days. But that's not the question I really want to ask you. It's about your reference to jurisdiction, the technical point. Now, High Court practice direction says pre-election matters should be instituted by way of originating summons. But the Supreme Court, yes, the majority decision was talking about rules of court, which says that you originate your protest, your appeal, by way of writ of summons. And that is the heart of the basic issue in this particular matter. I would like you to speak more to this issue of jurisdiction, because once the court raises the issue of jurisdiction, then whatever you build on it is a nullity, isn't so?
Thank you very much. And that's the point I was making. That's the point I was trying to make, a distinction between normal. Am I on?
Please go ahead. Yes. I'm with you.
Yes. Now, in normal cases, even rules of court can be bent to accommodate overarching interest of justice. In election cases, which is sui generis, regulated by its own special proceedings, that is marked by strict application of the relevant rules and procedure. Once you fall out of line, you run the risk of having your case terminated without the merit being looked into. Now, in pre-election matters, as against election petitions, practice direction cannot supersede the rules of court.
That's it.
And rules of court will not supersede the substantive law. But in election petitions, and that's the distinction, practice directions are embedded in the Electoral Act itself. So it will ordinarily trump rules of court, which applies by default where there's a lacuna. So this distinction, a lot of our colleagues have to bear them in mind. So in the case of pre-election matters, once the Supreme Court has now said that your practice direction violates or is inconsistent with the rule of court, then you must read those practice directions going forward, subject to their conformity with the rules of court. Whereas you will not have a situation like this arising in election petition, because the practice direction in election petition have been ruled to enjoy constitutional and statutory flavor and made pursuant to the Electoral Act, specifically to govern how election petitions are handled. Whereas pre-election cases are special civil claims having to do with matters preparatory to holding of general election. And so it is still the normal court that hears them, but subject to the rules. So practice direction of Federal High Court in election matter is not superior to, nor can it override specific provision of the rules of the Federal High Court, unless you can show that those directions are meant to address specific peculiar matters dealing with election matters. So from the moment the Edebe judgment was given, everybody, including the CJ of the Federal High Court, will appreciate the fact that every new action that has element of criminality will have to be commenced by way of writ of summons. Now, you see why I say it does not apply to election. Election petition can only be commenced by petition alone, not by writ of summons, not by written summons. So you can see the distinction.
All right, finally, sir, just to take away just a bit, because you're here, I'd like to use the opportunity to get your thoughts on a recent ruling by the High Court in Abuja restraining the president from postponing any further the date on the redesign of the Naira. And side by side, three governors taking the federal government to court, the president to court, asking that the president and the governor of the Central Bank of Nigeria to not phase out the 1,500 Naira and 200 Naira notes after February 10. I'd like you to get your thoughts on this, as there have been some contentions around the same jurisdiction. Do the courts have the power to restrain the president and the CBN governor from postponing the dates? Did you hear me, sir?
The audio is... Okay, I think I got up to the point of juxtaposing the suit at the Supreme Court and the other made in another suit at the Federal High Court.
Federal High Court,
yesterday.
exactly.
I got your comment up to that point. Now, you will see that whereas the case at the Supreme Court was initiated by states against the federal government in trying to activate the original jurisdiction of the Supreme Court, whether that is going to fly is a different thing. This case at the High Court was initiated by some political parties against CBN governor and I think the president, as well as some banks. The court having made that order yesterday, the proper thing for the court, for the other parties to do is to approach the court to have it revisited, because it was an ex-parte order. But I'm worried that political parties that just represent 3 or 4 entities will go to court and obtain an order, which in effect has pronounced upon the rights of customers of banks, contractual agreement between banks and their customers, that the bank must honor their order for payment against an instrument. And then the regulatory powers of the central bank. All of these were embedded in the order of the court that freezes the hand of CBN and the banks to honor their obligation to the customers of the bank. I'm not too sure how that will pan out. But the greater thing is that this is a clear demonstration that we have already brought the operating of the banking system into the theater of politics. I think we need to tread carefully. This was how June 12 was scuttled. We started having these funny orders from different courts in the pursuit of people's personal grievances. I think we must tread with caution. The matter at the Supreme Court, I don't know yet how it's going to pan out, but I think the hurdle for those who are filing the action is to satisfy the Supreme Court that there is indeed a dispute between those states and the executive member of the federal government, of such a nature that you can activate the original jurisdiction of the Supreme Court. It is possible, depending on how their case is couched, that a case of this nature can be made out under Section 5 of the Constitution. Because the executive powers of the president is supposed to be exercised subject to the Constitution itself and subject to acts of National Assembly. The president's power under Section 23 of the CBN Act allows the president to determine the reasonability of the time given by CBN in trying to redesign Naira. But it does not include expropriating rights of people to their financial assets held in banks. This is where I have concerns about what is going on. I have my money in my bank. Trading in my old note is different from asking me not to access my money that has value that is deposited in a bank. A bank has an obligation to honor a request of its customer. There may be question whether I can take that on by cash or whether I can take it by banking instrument. But you cannot limit, especially when the law is clear. Falan on SN has made this clear for almost 3 weeks now about the threshold of cash withdrawal allowed by the money laundering law. The idea of 10,000, 20,000 is totally at variance with the limit and restriction imposed on holders of bank balances to deal in their funds in cash. So these are some of the interesting things I believe events will throw up in the fullness of time.
Well, thank you very much, AJ Owonikoko SAN, for your insights. Thank you very much indeed.